Artificial intelligence, Hollywood strikes, and the right of publicity. The U.S. Senate Judiciary Committee's Subcommittee on Intellectual Property recently held its second hearing in 2 months on issues at the intersection of artificial intelligence and intellectual property rights. The most recent hearing focused on copyright law implications of generative AI tools like Midjourney and ChatGPT. As McKinsey & Company explains, generative artificial intelligence describes algorithms, such as ChatGPT, that can be used to create new content, including audio, code, images, text, simulations, and videos. As McKinsey notes, starry-eyed fans posted examples of the chatbot producing computer code, college-level essays, poems, and even halfway decent jokes. Others, among the wide range of people who earn their living by creating content, from advertising copywriters to tenured professors, are quaking in their boots. GPT is essentially a content recycling machine. It takes text, images, sounds, music, and other material that already exists, from the internet or the public domain or image banks or submitted by users, and mashes it up into something that's both new and old. This is especially problematic when the work of artists with distinctive styles is copied. As the BBC reports, fantasy artist Greg Rutkowski's name had been used as a prompt in AI tools that generate art that looks like his more than 400,000 times since September 2022, without his consent. Courts and legislatures are, or soon will be, wrestling with issues like the following. Does using copyrighted material, art, photos, books, magazine articles, blog, etc., to train AI constitute copyright infringement? Can a person's image or avatar, created or manipulated using GAI, be used without their consent? On the first issue, Matthew Sag, professor of law at Emory University School of Law, suggested at the recent hearing that using copyrighted material to train AI would be considered fair use under copyright law, in the same way that search engines and plagiarism detection tools are considered fair use. As the Los Angeles Times reported, more than 9,000 authors are calling out the tech companies behind generative AI in an open letter that states there is an inherent injustice in exploiting copyright-protected works to train chatbots without consent, credit or compensation. On the second issue, the committee discussed the possibility of a federal right of publicity, or laws that would protect people from AI-based impersonation. Impersonation could include both deepfakes, images, audio, music, and so forth manipulated for purposes of politics, pornography, etc. And virtual actors, who are artificially created using the scanned and recorded voices and images of real actors. State privacy and publicity laws now provide some protection from the unlicensed use of a person's image and voice. Do you have questions about how AI can affect your copyrighted work? Visit us at www.eonlaw.com. Eon Law. Unleashing Genius.